Thank you.
Testifying against,
Against it, yes.
is that correct? Testifying for
against.
yourself and against, right?
Against.
Yes. Go right ahead.
And I apologize again for not going through all of my bills today. Currently, right now, there are three, in family law, under the family code, property can be community separate and/or mixed. Property that is community or mixed can be divided by the just and right, how the court determines it should be divided. Separate property is a whole different animal, though. I'm involved in a case right now where after a divorce pending 4 years, no children, where 6 figures of community funds have been expended on legal fees, and now an attorney is trying to invade the separate property. They're kind of doing it under this. So I want you to read, I want to make sure we're not segueing into separate property somehow with this order. If we take and read this, and this is, will be falling under the family code, and you read, because in my case, they have filed, there's some case law out there where they're arguing you can file a partition suit on separate property within the divorce proceeding itself. So if you take this and you read this, with notwithstanding any provision of this chapter, the court that rendered a final decree of divorce or annulment or another final order substitute in there in order to partition separate property, which could be a final order. Dividing property under this title retains exclusive jurisdiction, giving the family court jurisdiction to render an order under this subchapter to divide property not divided or awarded to a spouse in our final decree. In my case, they're asking the court to partition. They invalidated the community property agreement. They are now seeking to, because that's invalidated, to partition separate property, lock the funds in the registry of the court, and then because the funds are in the registry of the court, and the court had the authority, the family court, to partition it, when the property code actually says a separate suit has to be filed after the decree, then what they're trying to do is invade the separate property for an award of attorney's fees or to change how those separate property funds from the sale of that property would be awarded. At all times, a partition of separate property should be done solely and strictly after a final decree. If you do it during the pendency of a case and you give this divorce court jurisdiction, this family court, to do this, then what happens is, in my case, I of course want to appeal the invalidation of the community property agreement, which gave him half of my separate property. There could be other issues. Just the deed could say you have 50-50, but maybe one person took on all the debt and used their separate property to completely remodel a property. In another instance, there may be inherited property that's separate property, and you are co-tenants, not just with your spouse as a separate property owner, but other heirs or people. In another instance, you may have joined with friends to buy another property. Now you're all co-tenants, and if all of that is partitioned, it gives the divorce court, the family court, the right to come in and decide how that's divided. If you do that without, before a final jury trial is rendered, it subjects that property, depending on if it's a 1031 property, or depending on the step-up in basis on how you acquired that property by deed, gift deed, whatever, an inheritance, you trigger capital gains. And anything dealing with capital gains, especially 1031 and rollovers, that's really strict federal rules and guidelines. So now in the midst of a divorce, we're dealing with a capital gains issue before final things have been decided. You're also dealing with the fact, by expanding the jurisdiction to this family court, they can, if they partition the property during the middle of the suit, and your separate property is partitioned, and you need that to buy another home or something, but you can't do it because you can't take out a mortgage during a divorce while it's pending. You don't have access to the rest of your community property, which has not been divided yet because there's no final decree. You haven't had a jury trial, so if one party acted in bad faith and withheld all the insurance proceeds from damage, how do you divide that? How does the divorce court divide that? If there's reimbursement claims because one person, even though they bought it 50-50, one person came in and totally remodeled the property, how does the divorce court deal with that? So I think we are kind of really expanding the jurisdiction of the divorce court, of the family court, a little bit too broad. That could potentially harm some people. I think the jurisdiction of the divorce court needs to be really limited, and it needs to stay instead of that final order dividing property. It should very explicitly state if you expand any jurisdiction to the family court, except for partition of separate property, which should occur only after a final decree. Give us the chance to get a final decree, to appeal any rulings in that final decree, for a jury to look at bad faith, fraud, any of those things like that, before we start partitioning off any property in this. If you look at section 9.204, and I'm a little confused where section 2 underneath it comes from. It talks about this act applies to a suit to divide property not divided or awarded to a spouse, and a final decree of divorce or annulment that's pending in a trial court. So separate property can only be confirmed. I'm in a pending divorce. I'm a little concerned that that's still going to segue and give that family court a little bit of jurisdiction there that they shouldn't have with respect to that separate property. 9.204 of the Family Code states, division of undivided assets when prior court lacks jurisdiction. If a court failed to dispose of property or subject to division of final decree, but the court lacks jurisdiction over a spouse or the property, and if that court subsequently acquires the requisite jurisdiction, which this now gives them jurisdiction, this bill, because right now they don't have jurisdiction over separate property, the court may divide the property in a manner that the court deems just and right. How we divide separate property is different than how we divide community property. How we divide mixed property is different than how we divide community property. So I'm very, very concerned that this could segue into us kind of getting into separate property issues versus community property issues or mixed property issues. I'm concerned about triggering capital gains in the middle of a divorce or even immediately after a divorce and not being in a court where we can deal with some of those tax implications or reimbursement things because the federal codes on capital gains are really strict. Let's say I inherited property, my husband gets 25%, I get 25%, my siblings get 25% through a will. My mother loved my son, my husband, and gave him a part of it in the will. We're now co-tenants. That should fall under the estates code. How we divide that property should fall under the estates code, but because we technically own it as separate property as co-tenants, you're putting us over here in the family code, but technically we're kind of also in the estates code because we acquired that through a will or a transfer on death deed or something. So again, I think we're kind of broadening the spectrum of the family court's jurisdiction in kind of in an inappropriate way. I think that we have to be really careful to do that. Because in this case, if we do that in the middle of a divorce action, and their attorneys are pushing for that, so then they can tap into the separate property for attorney's fees. And or we're not including reimbursement claims if we buy it 50-50, but I remodel it. I want my part back, right? How does the family court deal with that? That's actually why we partition after the final decree. And so I want to be careful that we don't say that other order, and that other order be a declaratory judgment, that other order be an order to partition, and then we bring the family court into the realm of separate property and making what they consider a just and right division of separate property. I think we always want to keep that separate property shielded and protected.
Thank you. Any questions, members? Representative Hood.
Thank you.
Thank you.
Oh, no, I'm sorry,
There's
ma'am.
a question, hold on.
I have a question, I'm sorry. So, just so I'm clear, section 9.201 of the Family Code is post-decree division of property, right?
Yes.
Okay. And under that subsection, there are 202, 203 dealing with undivided assets, division of assets. And I understand your fears, but educate me on this, and I mean this respectfully. My reading of House Bill 1916 just basically says that if a prior court made that final order and you have to go back to court to get a clarification of that final order, we're going back to the court that actually heard it versus like in 203 or 204, sending it off to a court that hasn't heard anything and having to basically relitigate it to a judge that hasn't heard it.
But that's just it. That order should never come from the family court. In order to partition doesn't come from the family court, where it's part of the divorce. It can only come after the decree. But in this instance, they are filing to partition separate property within the actual pending divorce before a final decree. There is a case that says you can partition property within a divorce. So now they're trying to partition all the separate property within the divorce before we ever get to the jury trial for bad faith, fraud, reimbursements. And then the property's gone, and it's going to trigger capital gains. You can't get a mortgage for a new property. We're into 1031 rollover issues.
No, I get that.
And so I want to be very, very clear when we say that other order and another final order, that we're being absolutely clear that a partition cannot take place within in the family code, in the family court, during the pendency of a divorce.
And just so I'm clear, but family judges, district court judges are capable, I can't think of the word, capable of ruling on all matters. I mean, when we get elected as a district court judge, we have in theory, the experience, the knowledge, the wisdom to handle the whole slew of statutes and laws under the civil code, right? I'm just asking, right?
Yeah.
I mean, judges can handle that.
In theory.
Okay, hold on.
Okay.
And I'm not trying to be rude, but I want to make sure I'm understanding you. And so my concern, or I'll be honest, I like this because my logic is our courts are congested. Forum shopping, like we've heard from the Supreme Court justice to district court judges and judges across the state, is a real thing. Efficiency is a real thing. And so, like in Bexar County, we have a presiding system. So every time you have a new setting, a new judge is having to relitigate what was already litigated. I want efficiency. And so the way I read this personally is that if a court rendered an order incorrectly, not correctly, I mean, all judges can make mistakes, but if a court rendered an order, and if we have to go back for a court to hear it, and they hadn't heard it before, then we're going to go back to the court that already heard it, that actually has some familiarity with it, because under 2.04 or under 2.02, there's already a limitations period. This isn't changing that. I mean, there's already restrictions, some restrictions. All this is saying is that if we're going back to court, that judge or that court should hear it so that they're already familiar with it.
Okay, but that, in my instance, and I was judge shopped, I'm assigned to a certain court, and in my county, judge shopping was allowed. An attorney called up, picked whatever judge they wanted, now you're over in that judge's court. But my issue with this is, in theory, yes, judges should be experienced in all matters. In my particular instance, my judge, it was some complex issues with declaratory judgments, postnuptial community property agreements, different things. My judge is completely confused about all of it. I mean, in the transcript, just tells you, I thought if I ruled on this, it took care of it. It's completely confused about it. Asked us to relitigate a same declaratory judgment 4 times. So the last thing I want is this judge handling this. And it also doesn't go to, you're coming back into the family court who's falling under the family, in this case, they're falling under the family code on the division of that property. But if I inherited that property with other co-tenants under a will, transfer of deed, whatever, I'm falling on the division of that property. House Bill 600 right now is falling and describing how those properties would be divided. That's under the estates code. That's not under the family code. I just want to be really careful what jurisdiction, that when we expand this jurisdiction and kind of broadly, that we're not giving the family court under the family code ways to divide that property or to award attorney's fees out of separate property. We never want to do that with separate property. We want to make sure how that property is divided and what to consider bad faith reimbursements, that kind of things. That it's not done in the middle of the divorce. And on the section 2 where it says that this may occur pending in a trial court. Okay, so in my case, I have a pending divorce. They're filing to partition in the middle of it. I want to make sure that that family court doesn't have any authority where it says, or another final order to partition that property in the midst of this divorce and trigger these capital gains and not give me due process to a jury trial to decide all these things. So maybe if you just simply put in there, accept order of partition, so we keep the separate property out of this until later on or something. But I hear what you're saying. I acknowledge what you're saying. But I think we are on a slippery slope where some attorneys are trying to invade separate property and put the funds in the registry of the court, and then say, court, you have jurisdiction over those funds, now award us attorney's fees or award these other things out of that separate property. And that's what I want to be careful doesn't happen.
And I get that, but, you know, and with all due respect to your experience, sounds like a horrible experience, but it sounds kind of like the chicken and the egg. I mean, I understand that you have a bad experience, but I think collectively, across the board, this amendment will be more efficient for courts in Texas. And all judges, even bad judges, are still adherent to the Code of Judicial Conduct. They're still sworn to follow the law. And even a family court isn't forced to put family law that they're hearing. I mean, if a specific law is supposed to be heard, you don't argue, you know, the judge is not supposed to follow an additional law. And I think collectively, this bill will address that thing.
Now, the other thing was, really fast, you mentioned is that, I apologize. I lost my train of thought, I'm so sorry. I've lost my train of thought. But again, thank you very much. I just want to make sure that we're not.
Hold on. Chairman Landgraf has a question.
Mr. Chairman, thank you. I think my question might be more appropriate for the bill author when he
Okay,
closes.
all right,
Thank
okay,
you.
thank you. Any other questions of this witness, members? Thank you,
Thank you.
thank you for being here. Chair calls Heather King, who is testifying from the Texas Family Law Foundation and for herself, testifying for the bill, correct?
Hello. First, I would, just for clarity on